Before World War I, it was the Democratic Party that opposed big government and wars of empire. Jefferson's vision of the best government as that which governs least and of trade with all countries animated Democrats for nearly 100 years. Regrettably, many of those Democrats were also racists who wrote into the law overt restrictions on African Americans that would not be undone until the courts stepped in. What presidents and members of Congress and state legislators refused to correct, life-tenured, black-robed judges did. Some of the agitation and some of the litigation that led to restoring the natural rights of blacks came from some unexpected sources, like African-American libertarians who, now educated and liberated from slavery, exercised their First Amendment liberties to challenge state laws that denied basic human freedoms. Where are these black libertarians today? Where are the libertarian liberals who believe in free speech and in free trade, in the right to look at pornography and the right to keep and bear arms, and the right to put whatever you want to into your own body, and in the right to life? Here to discuss the central role of libertarian ideas in the black liberation movement is Damon Root, associate editor of Reason Magazine and Reason.com, and one of my favorite Freedom Watch guests. We get to talk about things we don't ordinarily get to talk about. Now,
Thank you, Judge.
Pleasure to have you. Who would have known that Frederick Douglass and someone you've educated me about, Moorfield Story, were black leaders who were libertarians, who believed that government is best which governs least, and who agitated, and in the case of Story, litigated for that type of a government?
It's one of these unknown facts about American history. You know, Frederick Douglass, who escapes from slavery, teaches himself to read, to write, to become an abolitionist speaker, orator, and editor. He is a champion of a Jeffersonian and Lockean vision of natural rights, of individual liberty, limited government, and economic liberty. If you read Frederick Douglass's autobiography, My Bondage and My Freedom, he talks about when he gets his first paying job, says, now I'm my own master. I have the right to the fruits of my own labor.
Right, right. Something which was unknown to somebody who had been born in slavery. You and I were at a conference once where the Constitution was being hotly debated, and you reminded me of the debate between Frederick Douglass and William Lloyd Garrison. Garrison saying the Constitution was a pact with the devil, right, because it permitted slavery, condoned it indirectly. And Frederick Douglass, who escaped from slavery, said, no, it's not. It's the great instrument for freedom. Look at me, I'm free. And at the time he said this, blacks will soon become free.
Yeah, he called the Constitution a glorious liberty document. And he said, if you read it, you'll find that it gives no sanction to slavery. And in fact, it gives us self-ownership and the right to break free from our chains. You know, Frederick Douglass wrote this great letter to his former master. When he writes to him, he says, you are a man and so am I. And in leaving you, I took nothing but what belonged to me. This, like I said, this classic Jeffersonian Lockean idea of self-ownership.
Why does it appear, just from empirical observation, that there are so few African Americans amongst libertarians today? I mean, if you ask those basic questions that our friend David Bose asks in that test he likes to give people at Cato, which would you prefer, to live your life as you want it or to live your life as the government tells you? Almost everybody answers with the libertarian answer, as I want it. But where are black libertarian heroes or even black libertarian folks today in 2010?
You know, I'm not sure if I can give an answer to that. I mean, one thing I can say is I think that libertarians and classical liberals today have not done a great job of explaining why the libertarian vision is such a powerful force for liberating all humans and
right,
for liberating people throughout history. So the fact that these ideas played such a central role in both the anti-slavery movement and in the civil rights movement. So we talk about Moorfield Story, one of the founders right, of the NAACP, who is a classical liberal. I think this is an unknown history, and the relevance is not emphasized.
Tell us about the litigation that Moorfield Story, who became a lawyer, brought to the federal courts, and how it liberated blacks and whites to live and own property wherever they wanted.
Well, so he's a Boston attorney. He's born in 1845, and he's one of the founders and is the first president of the NAACP. And so he leads a lawsuit, which is the case of Buchanan versus Warley. And essentially what we have is, in Louisville, Kentucky, there is a Jim Crow residential segregation law.
Which basically prohibits what?
prohibits white people from living on blocks that are majority black, and blacks from living on blocks that are majority white.
So this is the force of the state government restraining whites and blacks from living where they might want to live.
Absolutely. You can own the house, but you can't live in it. So you can't use your own property the way you see fit.
All right, a law like that today is alien to our ears, but it was common at the time. What did Moorfield Story, down from Boston, do about this?
What he did was he argued that this is a racist violation of economic liberty, of the right to acquire and own property, and it violates black rights, and it violates white rights, it violates everyone's rights. And he wins. He convinces the Supreme Court. You know, the court has gotten a lot of things wrong on race. There's Plessy versus Ferguson, the separate but equal. There's the Korematsu decision where they uphold the internment of Japanese Americans under FDR. But this is a case where the Supreme Court gets it right on race, and they do it based on libertarian, classical liberal arguments.
How I wish that the court would have the same idea about property and about contract today. Basically, the court is saying in this case that you've told us about, which I must tell you is an unheralded case. I mean, you're talking to somebody who taught constitutional law for 13 years at a major law school, and I didn't know about this case. For some reason, it hasn't made it into the law school textbooks, but nevertheless stands for that proposition that the government may not tell you what to do with your own property. It can't tell the owner of a bakery what the owner has to pay the bakers, and it can't tell someone who owns a townhouse in the inner city to whom he can sell the house, and it can't tell the owner whether or not he can live there. These are private decisions that are quite plainly none of the government's business. Does the court still have that attitude about private property today, Damon Root?
Sadly, the majority on the court seems not to. If you look at the Kelo decision from a few years ago, the eminent domain case, the majority ruled that the government can take your property as long as they can put it to better use for raising taxes or raising revenue. Now, interestingly enough, Clarence Thomas, in his dissent in the Kelo case, he sort of channeled Moorfield Story. He channeled Frederick Douglass. He got these ideas exactly right. He noted that the bulldozers of slum renewal, of eminent domain abuse, they frequently target black neighborhoods and African Americans. So people with the least amount of power in our society, and historically blacks have been at the bottom due to the slavery and these reasons.
I was reading his dissent in the medical marijuana case the other day. That's where the majority said that even though the marijuana is grown in the backyard and never leaves the backyard, somehow this implicates interstate commerce, and so the feds can regulate it. And he said, does the Congress recognize any restrictions on its own power? Under this theory, the Congress could regulate a Tupperware party. Why does he say that? Because he understands the natural law. He understands that we have certain rights that come from our humanity, which even the almighty Congress can't take away.
I agree with Justice Thomas. I agree with you on that position. Sadly, you know, the majority of the court doesn't right now. And if you look at some of the arguments about the health care, about the individual mandate, requiring individuals to buy health insurance, that's justified as interstate commerce. So in other words, not buying health care is somehow qualifies as interstate commerce. Thomas got it right. Under this definition, anything goes.
I think the present court will invalidate that requirement. But who knows who'll be sitting on the court when the requirement makes its way there. Damon Root from Reason, it's always a pleasure.
Thank you, Judge.
Thanks for joining us.